When government authority expands in the name of safety and crime control, it is only a matter of time before liberty is treated as an inconvenience rather than a principle. This has become the state of the modern American justice system, where once unthinkable police practices have now been normalized. What do civil asset forfeiture, no-knock raids, qualified immunity, and mass surveillance have in common? They are each evidence that government officials can violate your rights with impunity as long as the motive is seemingly noble. Civil asset forfeiture is a practice that allows law enforcement to seize private property, cars, cash, even homes, without ever charging the owner with a crime, much less proving guilt beyond a reasonable doubt. The legal fiction used to justify this, absurd as it sounds, is that the property itself is guilty. The rationale goes like this: if an object is presumed to have been used in the commission of a crime, say transporting drugs or laundering money, it is considered guilty by association and thus subject to seizure. This allows the government to seize assets based purely on suspicion, placing the burden on the property owner to prove innocence in civil court, often at great personal expense. This concept flips due process on its head. Advocates of the practice argue that asset forfeiture is a means to combat drug dealers and organized crime, but the reality is that many of the people who lose their property are never convicted of anything. The process is so burdensome that reclaiming your own belongings can cost more in legal fees than the value of what was taken. In a free society, property rights should not be subject to the suppositions of badged bureaucrats. You cannot be considered free when your belongings can be taken by force without a trial. This is simply a corrupt authoritarian power play disguised as law. No-knock raids are the law enforcement practice of storming into people's homes without warning, often under the pretense of catching suspects before they destroy evidence. These raids are perhaps useful for hostage situations or imminent threats, but they have also become routine in drug enforcement. These encounters frequently result in injury, death, and traumatized families. Sometimes the police break into the wrong home. But even when they get the address right, the method itself is a violation of basic liberty. The Fourth Amendment was supposed to protect citizens from unreasonable searches and seizures. But what could be more unreasonable than a militarized team smashing down your door at 3 a.m., guns drawn, to enforce a non-violent drug warrant? Nonetheless, the courts have continued to uphold this practice in the name of officer safety, forgetting that the primary goal of policing is the protection of individual rights, not government risk management. And don't assume that police are held accountable when they overreach. They are often not. Under qualified immunity, the doctrine invented by the courts that shields government officials from civil lawsuits, police can indisputably violate your rights, and you may have no legal recourse. Citizens rightly resent the double standard, where the public is held strictly accountable under the law, but government agents are not. Asset forfeiture, no-knock raids, and qualified immunity are all defended as necessary tactics to fight crime, terrorism, or drugs. But what cannot be rationalized away is that each promotes an expansion of government power and a contraction of constitutional guarantees. Then there is the tortured reasoning for mass surveillance. After September 11th, the federal government began collecting phone records, internet data, and even banking information on millions of Americans, not because they were suspected of any crime, but because they might one day be relevant to an investigation. This mindset corrupts the presumption of innocence into a presumption of suspicion. The government expects us to acclimate to lost liberty as a reasonable trade-off to ensure our safety, as if doing so is the only alternative to chaos. But government lawlessness is never the answer to anything in a free society. Those who enforce the law must also be bound to it. Government power must be exercised under rules that protect the innocent, not just punish the guilty. There is a reason the Bill of Rights placed so many limits on government power. The founders understood that the gravest threat to liberty is not a mob or a foreign army, but the slow, incremental expansion of domestic authority under the guise of security. Benjamin Franklin keenly observed that those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. Certainly we need police, but a free society must insist that the agents of the state rigorously honor rights while they carry out the task of imposing responsibilities. A government that can take your property without trial, break into your home without warning, shield itself from accountability, and monitor your movements without a warrant is not a government of the people or of the Constitution. It is legalized lawlessness. Once the state gets too big for its cage and has little interest in restraining itself, it is left to the people to do that for them.
Can you say why America is the greatest country in the world?
Freedom and freedom. So let's keep it that way.
Well, I think it's time we ask ourselves if we still know the freedoms that were intended for us by the Founding Fathers.
Everything in the Bill of Rights tells the government what it can't do to restrict my freedom.
Make government more the servant and not the master of us all. In this free nation, we do not choose to be ruled. We elect to be governed.
Do not support your own oppressors. Stop letting the system exploit you.
I think that the real job that we have that confronts us is to somehow be able to sell our fellow Americans on the moral superiority of personal liberty.
I would remind you that extremism in the defense of liberty is no vice.